Hey guys, how's it going? Welcome back to the channel. My name is John, and today we're going to be talking about whether a will needs to be notarized. Hey guys, how's it going? Welcome back to the channel. Again, my name is John. Today we are going to be talking about whether a will needs to be notarized. Now, before we get started, make sure that you subscribe to the channel just by hitting the subscribe button below. And if you do, make sure that you write into the comment section, I subscribed, and I will make sure that you get a personalized response from me. So today we are going to be talking about whether a will needs to be notarized. And it's an interesting question that I get from time to time. So we probably need to talk about exactly what a will is, because when people come into my office, they often confuse exactly what a will is. And as an example, just 2 weeks ago, I had a guy call in, said he needed to talk about a will. He came into the office and he was actually talking about a living will, not a last will and testament, which we're going to be talking about today, but a living will. And those are two entirely different documents. So we're going to be talking about a last will and testament. And the last will and testament is the document where you prescribe your wishes and desires as to the distribution of your assets once you pass away. It's called the last will and testament. So people want to know whether it needs to be notarized. And so you do want to have a notary handy, but not for the reason you might think. See, Georgia law and every state will dictate what makes a valid will. In most states, you do not need a notary to create a valid last will and testament. You'll often need witnesses. Sometimes you'll need one. In Georgia, you happen to need two. But you will need the witnesses. So you create a will, you get the witnesses to sign it, and it has all of the characteristics of a valid last will and testament. So where does the notary come in? Well, back in the old days, imagine in 1905, somebody living in rural Georgia, and they created a will. Just think about it. Would they have a notary handy to sign off on this last will and testament? Probably not. But they wanted to create a last will and testament. In fact, last will and testaments, they've been around for thousands of years. And so if you just think about it practically, this person living in 1905 in rural Georgia, they just wouldn't have immediate access to, a notary. So, over time, it wasn't required that you need a notary for a last will and testament, but you do want to have one handy for this reason. So imagine this person creates the will, they pass away, and their family goes down to the local probate judge and says, here is the deceased person's will. We need to distribute out their assets according to the will. Well, how is the judge going to know that that is that person's will? How is the family going to prove that? And proving is the important part of why you need the notary handy. Even though the witnesses signed it saying that they saw the person sign the will, that's pretty much all it says, is that they saw the person sign the will. So back in the old days, what you would have to do is you would have to have those witnesses come down to the courthouse, testify under oath. Hey, I was there that day. I saw them sign it myself. They were of sound mind. They were of a valid age, whatever that happens to be in your state. In Georgia, it happens to be 14, the lowest in the nation. Can you imagine a person can write a will, but they can't get a learner's permit to drive? But that happens to be the case here in Georgia. So they'd have to come down to the courthouse, testify under oath. Hey, I was there that day, saw them do all these things. But you can imagine what would happen over time is that sometimes the witnesses themselves would pass away before the person that wrote the will. Or maybe they moved to Texas. You just wouldn't be able to find them. So bringing them into the courthouse would be problematic. 1905, it might not be so problematic because the person that signed the will was probably right down the street. Just travel wasn't as ubiquitous as it is today. So it's become much more problematic. So how does the family prove the will? Well, they prove it with a document called the self-proving affidavit. This affidavit says the same thing that these witnesses would normally say had they come down to the courthouse and testified under oath. It would say, hey, I was there that day. I saw them sign it. They're of valid age. They're of sound mind. They know who we are. They asked us to be witnesses. various other things. And that document will be signed by the person who wrote the will. This person is called a testator, by the way. The person that wrote the will and the witnesses. Now, that document will be notarized. So that's why you need to have the notary handy. So you've got the last will and testament, and you have a document called the self-proving affidavit that will need to be notarized. So have the notary handy, not for the will, but for the self-proving affidavit. So what happens if someone today in 2022 they create a will and they don't have this self-proving affidavit? Well, you guessed it. We're going to have to go out and try to find these witnesses. Hopefully they are able to be found. Hopefully they haven't passed away. Hopefully they are cooperative. We have had cases where, maybe somebody wrote a will in the 1980s and they pass away recently. They bring in the will and there's no self-proving affidavit. And we've got to go try to find these witnesses. Believe it or not, we have often had success finding these witnesses. But sometimes when we contact them, they say, yeah, I remember being there and I remember signing it. And we ask, well, can you help us out with, proving this will for the family? They said, no, I'm not interested. I just don't want to get involved. And so you spend a lot of time trying to find these people just to find out they're not going to be cooperative. So self-proving affidavits were kind of sporadic before the year 2000. In the year 2000, it really started to become ubiquitous. But there are still people today that create wills and don't have self-proving affidavits attached to them. And it's very problematic. In fact, I don't know, but it may be malpractice for an attorney to prepare a will these days and not have a self-proving affidavit attached to it. I don't know. That would have to be determined by court. But I've never done a will and not done one of these self-proving affidavits attached to it because it's just that important. Can you imagine trying to find these people? Oftentimes these people are employees at the law firm. You may meet them for 4 minutes while you're signing the will. I mean, how do you, other than their address, which is on the will itself, the address really isn't required, but oftentimes their address is on there. How would you go about trying to find them? Write them a letter or look them up on the internet? It becomes very problematic. So you should have a notary handy, not necessarily for the will, but for the self-proving affidavit that goes along with it. A person writes a will, they get the witnesses, the right witnesses, by the way. They get the witnesses, they get the self-proving affidavit, they get that notarized. That person passes away, the family takes the will and the self-proving affidavit down to the court. It makes things much smoother, much smoother. Again, probate is a process, but the process doesn't have to be too difficult as long as you have that will and the self-proving affidavit attached to it. So the question whether a will needs to be notarized, it will depend. Of course, you got the lawyer's favorite answer, it depends. But it will depend on your state law. Most states do not require a notary in order to create a will. Here in Georgia, you don't need a notary to create a will. You do want to have a notary handy, though, so that the witnesses and the testator can sign that self-proving affidavit and have that document notarized. Keep those two documents together so that your family can find both of them once you pass away. So you do not need the notary for the will, but you do need a notary handy so that they can sign that self-proving affidavit once everybody signs all the documents. You want to do them at the same time, sign the will and self-proving affidavit at the same time. All right, so I hope that helps you understand whether the will needs to be notarized. Again, I hope you've subscribed to the channel. Again, if you do, just put in the comment section below, I subscribed, and you will get a personalized message from me. I really appreciate it, and I hope you enjoyed the video, and until we create the next video together, I will see you then.